In the last video, I discussed violations of the exclusive right to reproduce the copyrighted work in copies or phonorecords. Violation of that right requires that the alleged infringer have copied protected expression. We divided this requirement up into two elements: copying and improper appropriation. We also discussed how copying can be proven and what constitutes improper appropriation, that is, the copying of original expression that's protected by copyright. Today I'm going to talk about the other 5 exclusive rights listed in Section 106. We'll start with number 3, then circle back to number 2 at the end. So once again, let's jump right into the statutes. Section 106.3 provides the copyright owner with the exclusive right to distribute copies or phonorecords of the copyrighted work to the public by sale or other transfer of ownership, or by rental, lease, or lending. This right allows owners to control the distribution of their works. But it's also subject to an important limitation, which we refer to as the first sale doctrine. 17 U.S.C. Section 109 states that notwithstanding the provisions of Section 106.3, the owner of a particular copy or phonorecord lawfully made under this title, or any person authorized by such owner, is entitled without the authority of the copyright owner to sell or otherwise dispose of the possession of that copy or phonorecord. In other words, when Section 109 comes into play, we say that the author's exclusive right of distribution has been exhausted by the author's own sale of that particular copy of the work. Here's an example. This is a copy of a used book that I purchased from a used bookstore. At some point, this book was sold by the publisher to somebody. That person presumably read the book, then sold it to the used bookstore. And then the used bookstore sold it to me. Even though the list price of this book is $6.99, I paid only $1.50 for it, none of which went to the copyright owner. And the copyright owner had no control over the transfers of ownership of this copy of the book after it was initially sold, notwithstanding what Section 106.3 says. Of course, the owner of the copy cannot copy the copy and start selling copies of the work. That would still violate Section 106.1. At this point, you might be thinking, if there's already an exclusive right to make copies, and the exclusive right to control distribution of the work is subject to the first sale doctrine, what's the purpose of this Section 106.3? The answer is that the first sale doctrine isn't absolute. There are situations in which possessions of a work might be transferred that aren't covered by the first sale doctrine. In addition, Section 106.3 is particularly important in the context of electronic transmissions of digital files, where the provider of the digital file is not itself making the copy. It's just distributing the file via transient signals through the internet. The next set of rights are the copyright owner's exclusive rights to perform or display the copyrighted work publicly. You might have immediately noticed a few things about these rights. First, these rights only apply to certain types of works. The exclusive right of public performance only applies to literary, musical, dramatic, and choreographic works, pantomimes, motion pictures, and other audiovisual works, while the exclusive right of public display only applies to those works plus pictorial, graphic, and sculptural works, and the individual images of a motion picture or other audiovisual work. And Section 6 only applies to sound recordings. If you think back to the list of works in Section 102, though, you'll see that these lists pretty much encompass all the types of works. The big one that's missing from the right of public display is architectural works, which, because they're embodied in buildings, have more limited rights. Similarly, the right of public performance doesn't extend to pictorial, graphical, or sculptural works, which makes sense because while one can display a work like this, it's hard to imagine performing that kind of work, especially in a way that isn't already covered by one of the other rights. Another aspect of the rights of public performance and display that you may have noticed is that it requires either performance or display of a work. These terms are themselves defined in Section 101. To perform a work means to recite, render, play, dance, or act it, either directly or by means of any device or process. Or in the case of a motion picture, other audiovisual work, to show its images in any sequence or to make the sounds accompanying it audible. Displaying a work means basically the same thing, showing a copy of it, either directly or by means of some kind of device. In the case of a motion picture, other audiovisual work, displaying a work can also mean to show individual images non-sequentially. For example, if I were to recite a poem by Robert Frost, I'd be performing that poem. Or as I show you this picture of the Mona Lisa, I'm displaying that work. In addition, all three of these rights require that the performance or display of the work be done publicly. Section 101 also defines this term, specifying that in the context of performance or display, publicly means one of two things. First, it can mean to perform or display it at a place open to the public, or at any place where a substantial number of persons outside a normal circle of family or social acquaintances is gathered. For example, if I were to recite that Robert Frost poem while standing in the courtyard of the law school, I would be performing that work publicly. On the other hand, if I were to recite it while sitting in my living room with only my family in attendance, I would not be performing that work publicly under the first part of this definition. However, performing or displaying a work publicly can also take the form of a transmission of the work. For example, if I were to appear on a radio broadcast reciting the Robert Frost poem, I would be performing it publicly, even if I were sitting in my living room. The last thing to know about the right of public display for now is that it's also subject to some extent to 17 U.S.C. Section 109, in this case Section 109C. That section states that the owner of a particular copy lawfully made under this title, or any person authorized by such owner, is entitled without the authority of the copyright owner to display that copy publicly, either directly or by the projection of no more than one image at a time to viewers present at the place where the copy is located. In other words, someone with a lawfully acquired copy of a painting may hang that copy on the wall of a public place without violating the exclusive right of display. But this exception does not apply, for example, to a work that's hung on the wall of a room that appears in a television show, because the viewers of that show would not be present at the place where the copy is located. Finally, let's turn to derivative works. In addition to the right to make copies, copyright also explicitly includes the exclusive right to prepare derivative works. So, what's a derivative work? Section 101 defines a derivative work as a work based upon one or more pre-existing works, such as a translation, musical arrangement, dramatization, fictionalization, motion picture version, sound recording, art reproduction, abridgment, condensation, or any other form in which a work may be recast, transformed, or adapted. For example, someone who translated Harry Potter and the Sorcerer's Stone into French would have created a derivative work. The movie adaptation of the work was also a derivative work. The next case that you'll read, Pickett versus Prince, involves the creation of a derivative work. Unlike some of our other cases, this is not a Supreme Court decision or a Circuit Court decision that's viewed as a core copyright law canon. Instead, I chose it because it illustrates what a derivative work is and allows us to talk about some of the issues that derivative works can raise. Because of that, I want to be clear at the outset that this is not the only way to analyze derivative works. At the same time, it highlights some key tensions in copyright infringement that are worth discussing. Plus, it involves Prince. Really? That's great! Lost and Found just called. They found my Raspberry Beret. With that, I'll leave you to the case.